the topic of these two decisions have been something which came as a significant development so far as charitable trusts are concerned, because till then, charitable trusts, the way the law was understood was quite different. In the case of these two decisions, the hearings took place in March 2022, and the rulings were delivered only on 19th of October 2022. And there were many SSCs involved in both these sets of cases. The first set of cases related to the educational institutions, and which is what is governed by, which is in this new Noble Educational Society. That was the lead case decided by the Supreme Court. And so far as the other this was concerned, you had various types of SSCs involved in that, and that was in relation to the proviso to Section 215, which, as you know, has come in with effect of assessment year 2009-10, and which applies to when you have objects of advancement of general public utility, and which this involves statutory housing boards, corporations, urban development bodies, certain regulatory bodies, including the Institute of Chartered Accountants, trade promotion organizations, certain non-statutory bodies set up by the government, cricket associations, and other organizations. So this was, these two decisions. Abhitan mentioned that I will be taking question and answers after the first decision on that decision. I think what I will be dealing with is the issues relating to that. That is what I will do is, for each of these decisions, I will take you through the decisions. Then we'll deal with the issues which arise from these decisions, and thereafter then go on to the next decision and the issues arising therefrom. And finally, we will take questions and answers. So that's the way I would like to take this presentation. So the first decision, as I said, is that related to education. And the question here was, relating to registration under Section 1023C6. As you know, under Section 1023C6, an educational institution existing solely for the purpose of education and not for the purpose of profit is entitled to the benefit of exemption. And as you know, under Section 1023C, you have as many as 23 or 24 provisos. I think you tend to lose count of the number of provisos which are there in that section. But this is something which is a significant exemption for, particularly, you have other clauses which also deal with educational institutions, but this is for the large educational institutions which are not wholly and substantially financed by the government, where the gross receipts is more than 5 crores. They are required to be approved under 1023C6. And the issue which arose before the Supreme Court was, what is the correct meaning of the term solely for the purpose of education, which is contained in Section 1023C6. The proper manner in which any gains, surplus or profits, how are they to be treated for the purpose of assessment when an educational institution has such gains, surplus or profits. And then, in addition to the fact that it exists to impart education, whether the tax authorities at the time of registration of that or approval under 1023C6 can look at whether you have satisfied conditions of the other state laws, whether you are registered under the state law as you are required to be registered, and if you are not registered, whether they can deny the benefit of exemption. This case of New Noble Education Society arose from Andhra Pradesh High Court, where the Andhra Pradesh High Court had taken the view that if you are not registered under the Andhra Pradesh Local State Act applicable to charitable institutions, you would not be entitled to the benefit of exemption. So that was the pattern in this case. So these were the issues which were before the Supreme Court, and the questions, the Supreme Court, when they looked at the whole history of the concept of education which was there, and they looked, in fact, went right to the 1922 Act. They looked at trustees of the Tribune, P. Krishna Warriors case. Then they came to Lok Shikshan Trust case, and in that they looked at what is the meaning of education, which was enunciated in Lok Shikshan Trust case, and they said that education, that is imparting formal scholastic learning, is what the Income Tax Act provides for under the head of charitable purposes under Section 250. So that this thing was cited with approval by the Supreme Court over here. And then they referred to the subsequent decision of Indian Chamber of Commerce, which followed Lok Shikshan Trust, where they said that profit making cannot be an object in case of a trust set up with object of advancement of general public utility. They also looked at Surat Art Silk Cloth Manufacturers Association Supreme Court decision, where there was a predominant, where the Supreme Court had said that you have to look at the predominant object of the trust. When it is carrying on certain activity, what is the predominant object? And they said that, however, was a case of advancement of general public utility. It was not a case of an educational institution governed by Section 1022. At that point of time, the exemption was under Section 1022 and not 1023C. And 1022 had a simple two-line thing saying that existing solely for the purpose of education and not for the purpose of profit. That was the simple of this. You didn't have all these 23, 24 provisos under 1022. And the Supreme Court then summarized the position. They said that if you're a society or an institution which is running schools and colleges, and the schools or colleges are imparting education, then you yourself is, your sole object is to impart education. And so just the fact that the schools or colleges impart education, not the society or trust itself directly, that cannot result in rejection of the claim. And they said that for determining whether you are engaged in education or not, you have to look at your objects clause. It's not the activity that you look at, but you look at the objects. That was what Adityanar Educational Institution, the view which was taken by the Supreme Court there. Then they looked at the decision of the Supreme Court in Oxford University Press, where he said that if you're a university outside India, but in India you're carrying on only some activity of printing of textbooks, you have to be actually carrying on activity of education in India to be entitled to the benefit of exemption under Section 1022. Then they went on to consider the decision in American Hotel and Lodging Association Education Institute, again a Supreme Court decision, and where the American Hotel and Lodging Association, in that case, the Supreme Court said that they borrowed the concept of predominant object from Surat Art Silk Mills, and they said that whether your exemption is to be allowed or not will depend on your predominant object, and whether and to what extent profits are generated, how they are utilized. That is not essential. You don't look at that at the time of approval, but that will apply at the time of whether you're entitled to the benefit of exemption or not. In each year, you have to look at that. That was the view, and not at the time of approval. That was what American Hotels case said. And then ultimately, Queen's Educational Society, which was where substantial profits were, surplus was being earned by a school which was carrying on educational activities, where again the Supreme Court approved the predominant object test and referring to Surat Art, and it held that merely that substantial surplus of profits cannot be a bar for rejecting the application for approval under 1023C6. So that was the summarized version of the position as when the Supreme Court considered. Then they said that went on to analyze the provisions of Section 1023C6, and they said that when you're saying that, well, they're looking at existing solely for educational purpose and not for purpose of profit, you don't consider the 7th proviso, which talks about a business incidental to attainment of objects and separate books of account maintenance. Don't talk about that. And they said, look at the plain and grammatical meaning of the term sole or solely, which means only or exclusively, and that does not mean predominant or mainly. It means solely means to the exclusion of all others. That means you have only this and nothing else. And they said that in the previous decisions, the Supreme Court did not explore the true meaning of the expression solely. And the applicable test, which was enunciated in Surat Art, that was in context of general public utility. That was wrongly applied. It was applied unquestioningly in cases relating to charitable institutions claiming to impart education. That is in American Hotel and Queen's Education. That was there. And then they said the obvious error in the opinion of the court, which led to the previous decisions in American Hotel and Queen's Education Society, was that Surat Art was decided in the context of a society that did not claim to impart education. It was set up to advance objects of general public utility. And then they said that the approach and reasoning, which is applicable to charitable organizations set up for objects of general public utility, is different from charities set up or established for object of imparting education. And the positive condition, which is solely for educational purpose, and the negative injunction that not for purpose of profit, that is what you have to look at is necessary for the purposes of exemption. And then they said that therefore an entity which is imparting education should necessarily have all its objects aimed at imparting or facilitating education, because solely for the purpose of education it has to be. So the objects have to be only for the purpose of education. And they said that how do you interpret Section 1020C? It must solely exist for the objected professors, that is education or educational activity only and not for profit. And then, of course, they said that the 7th proviso carves an exception to this rule, and it allows that if it is provided business is incidental to attainment of objects, it allows you to earn profits. But what is the meaning of incidental? And they said incidental means that is the objects are related, it should be something connected with the objects, something connected with the activity of education. That's the way you have to look at it. And then they summarized the position saying that the trust seeking approval or exemption should solely be concerned with education or education related activities. If incidentally, while carrying on those objects, it earns profit, it has to maintain separate books of accounts as required under the 7th proviso. And it is only under those circumstances that business income can be permitted, provided that the business or activity which you're talking about is education or relating to education. So that was one part of the decision. Then the second part of it is what is the scope of inquiry by the prescribed authority, and whether you have to the prescribed authority has to look only at the objects of the society when it seeks the approval under 1020C, or whether it can look at what are the activities, etc. And they said that in American hotels, the Supreme Court was of opinion that question of application of incomes can arise only at the stage of assessment, and the audited books of accounts are of no relevance at the stage of registration. Now, they said that looking at the plain language of the section, which refers to the procedure for approval, there do not seem to be any such restrictions. And therefore, the prescribed authorities hands are not tied in any manner. But the American hotels decision has overlooked this discretion to look into the past history of the accounts which is there and to discern whether applicant was solely engaged in education. In the American hotels case, the Supreme Court had stated that accounts may not be available, and therefore the Supreme Court here in this case said that it assumed that only newly set up trusts may apply for exemption. It applies equally to existing trusts, which may seek exemption at a later point of time. And therefore, accounts is something which, so ordinarily the inquiry should be confined to the nature of income earned, and whether it is for education or education related objects. But if the surplus of profits are generated in the hands of SSC in imparting of education related activities, disproportionate weight ought not to be given to surpluses of profits, provided they are incidental. At the stage of registration or approval, focuses on the activity and not the proportion of income. If the income generating activity is intrinsically part of education, the prescribed authority on that basis alone cannot reject the application. So that was what they said so far as the approval process is concerned. Then on the state laws is concerned, they said that requirement of registration of every charitable institution is not optional. Apart from the fact that there are penal consequences, the Andhra Pradesh Charities Act, such local laws provide the regulatory framework, annual accounts, choosing governing body, acquisition and disposal of property are constantly monitored. And so therefore, charitable institutions have to comply with those laws. They said that they looked at the Andhra Pradesh Charities Act and they said that requirement of registration is mandatory under that. And therefore, compliance with or registration under those laws are also a relevant consideration which can legitimately weigh with the prescribed authority while deciding application for approval under 1023C. That was what they held. Then, what does they mean by incidental or business activity? The Supreme Court went on to consider that. And then they said that imparting education through schools or colleges and other such institutions, that is per se charity, that is by itself charity. What is incidental? They gave some examples. If an institution facilitates learning of its students by sourcing and providing textbooks, such activity would be incidental to education. And there they relied on the Supreme Court decision in the case of Assam Textbooks Bureau. They said that that is the education. This was if it facilitates learning, but here they're talking about learning of its pupils by sourcing and providing textbooks. Then they give an instance, if a school or education institution runs its own buses and provides bus facilities to transport children, that too is an activity incidental to education. Similar things is summer camps for pupils, special educational courses such as related computers, etc., which may benefit pupils in their pursuit of learning. That would also amount to incidental activity. Then they said that providing hostel facilities to pupils would also be an activity incidental to imparting education. If it provided hostel and allied facilities such as catering only to its students, then it is incidental to the objective of imparting education. So very important here, they say that if I'm running a school or a college and I'm running a hostel which is only for my students, then it is incidental to the objective of imparting education. Then they went on to say that under other situations they've looked at, they said that if the institution provides premises or infrastructure to other entities, trusts for purpose of conducting workshops, seminars, or even educational courses, which this trust is not actually imparting, and outsiders are permitted to enroll in such seminars, workshops, then the income from such activity cannot be characterized as part of education or incidental to imparting of education. Such income will fall under the other heads of income. So they said that this income is not incidental activity. It is not incidental to the imparting of education. It will fall under other heads of income. And then they summarize the conclusions, they summarize the conclusion. And if you read the judgment, you will realize it's a 52-page judgment where they've said that the requirement solely engage in education is that it cannot have objects which are unrelated to education. All the objects have to be in relation to education. Where the object appears to be profit oriented, it would not be entitled to 1023C approval. But where surplus accrues in a year or set of years, it is not a prohibition, provided such surplus is generated in the course of providing education or educational activities. And then 7 provisos they refer to. The reference to business means that business which is incidental to educational activities, which we saw. They disapproved the American Hotel Means Education Society so far as they related to the interpretation of the expression solely. So to that extent, only those decisions have been overruled. And then the prescribed authority, he can look into the accounts, etc. He's not constrained from examining accounts, they said, and registration under other laws, and then they referred, of course, to the recent insertion of the proviso to 1023C with effect of 1st April 21, which says compliance with the requirements of other laws. That is supports our argument. So that was the way the Supreme Court looked at it. And then the Supreme Court observed that since this judgment has departed from the previous rulings regarding meaning of the term solely, in order to avoid disruption and to give time to institutions likely to be affected to make appropriate changes and adjustments, it would be in the larger interest of society that the present judgment operates hereafter. As a result, it is hereby directed that the law declared in the present judgment shall operate prospectively. Now, the question here is only in respect of the term solely, I think the decision will operate prospectively, not the entire judgment. It's only, so what they're saying is that if today you have multiple objects, say maybe 10 of which are educational, and you have one which is medical and one which is of general public utility, then you don't fulfill the requirement of solely for the purpose of education. You are now allowed to amend your articles or your memorandum or your trust deed. We give you time to do that. And therefore, this judgment will operate prospectively. Now, the question is, what do you mean by prospectively? Will it mean from assessment date 23-24 onwards, or from 24-25 onwards, or for assessment after the date of judgment? I think it will mean only from assessment date 24-25 onwards, because till assessment date 23-24, you would still have those clauses. You will now take steps to amend those clauses, and therefore, ideally, what you should do is amend those clauses, remove those other objects if you want to fit in within 1023-6. You will have to remove those other objects by 31st March 23. Ideally, you should do that so that at least from 24 assessment day 24-25, that is not an area of dispute. So that's the way. Now let's look at some of the issues which arise. Now here, what you have to remember is that this decision will apply even to clauses 3AB and 3AD, though it was only 6A, clause 6, which was the subject matter before the Supreme Court. But the same logic will apply even to clauses 3AB and 3AD. 3AB is a situation where you're wholly and substantially financed by the government. 3AD is a situation where the trust is, the gross receipts of the trust is less than 5 crore. So therefore, in those cases also the term uses solely for the purpose of education. So any educational institution, whether claiming under 3AB, 3AD or 6, if it has other objects, it's advised, I think it's advisable to tell them that, yes, you need to amend your objects to drop those clauses, other objects. Particularly if you're following under 3AB and 3AD, there, it's an automatic exemption, there are no conditions. And therefore, if you want to continue the benefit of that, you should amend your objects clause, that's very clearly. Does it apply to medical institutions which fall under clause 6A or 3AC or 3AE? Technically, this decision applies only to educational institutions, not to medical institutions. But if you look at the language of clause 6A, it says solely for philanthropic purposes. Medical institutions solely for philanthropic purposes. Now, when you say solely for philanthropic purposes, it means solely for charitable purposes. Now, therefore, if you have charitable purposes and something which is also not charitable, or something which is, something which falls under other objects, then I think this could result in a problem so far as this is concerned. Then the next issue which arises of the Supreme Court decision is, how do you determine whether the objective appears profit-oriented? Would the fact that you're having a regular large surplus from the activity make the objective profit-oriented? Is that the way you look at it? what the Supreme Court seems to be indicating is it because the predominant object test has been, so far as the Supreme Court is concerned, says don't look at the predominant object, because in the predominant object, what the Surat Taxation say, Supreme Court said, you look at what is your main object. Is it carrying on charity or is it earning profits? If it is earning profits, then you're not entitled to the benefit of the exemption. If your main object is charitable, but incidentally you're earning a surplus, that does not, you do not cease to be charitable. You will continue to get the benefit of exemption. So that has been given a go by now. The predominant purpose test has been given over. So what happens then in this situation? If the main activity itself is generating a large surplus, what would happen? What would happen in this situation is a question mark. Would say that therefore it is not solely for the purpose of education. It's not or not for purpose of profit. So that is the question. If you are making, and which was the issue in Queen's Educational Society. Now, Queen's Educational Society has been overruled only to the extent that it said that so far as the predominant purpose test is concerned, that was the part of it which was overruled. The question here is then, how does one determine in such a situation whether the objective is profit oriented or not? I think Supreme Court has not really given an answer, but possibly the way Supreme Court has looked at it, when you read the next decision and put the two of them together, you realize how the Supreme Court is looking at this. Now, another issue is if your main activity of education itself is generating a large surplus, and if the department is likely to regard that as the business, then how does one maintain separate books of account for business? That is another question which arises. And the next issue is, the Supreme Court has said formal scholastic education. Education means formal scholastic education. So they've taken us back 48 years to 1976 in Lok Shikshan Trust case. Lok Shikshan Trust, when the Supreme Court had said formal scholastic education, the normal classroom education is what they had said. Various courts, including the Gujarat High Court, Bombay High Court also, they had all read this down. They said that normally, yes, it means formal scholastic, but there are certain types of education for which classroom teaching is not the best. And there have been, for instance, in Bombay Productivity Council case, they said that holding of seminars, educating the public, so all that is also education. There was Ahmedabad Management Association where they said that yes, education, executive development programs, etc., all that would also be education. So the question is, when you say formal scholastic, what do you mean by scholastic? Scholastic, if you look at the dictionary meaning of the term, it means a school or colleges. And if you look at the arguments of the additional Solicitor General in this case, the argument was he relied on the TNA Pai Foundation Trust case, etc., which was in the context of capitation fees. So there, the Supreme Court had laid down the whole concept that what is meant by education is, and which is also again what the additional Solicitor General argued, he says that what is meant by that is primary and secondary education and college education, including professional education. So at least professional education will certainly fall with that. But now the question here is, what about, would you say that therefore only classroom teaching is what is covered? And is it only government recognized courses which is covered? Because if you have somebody, say today you have a management institute which is running various courses. Most of those courses are degree courses or diploma courses which are recognized by the university. But there are 2 or 3 courses which it is running which are not recognized courses. Say for instance, the executive development program it has, which is for executives and which is say a part-time program, etc. Now in that situation, since it is not a recognized degree so would it be formal scholastic education? There may be classroom teaching. There may be a different form of teaching. Would that be formal scholastic education? I think that is something which, or would it then be regarded as an incidental business? Possibly it may be regarded as an incidental business in the way the Supreme Court has interpreted this, and this is going to create a problem. Then on the incidental business also, on certain activities, would these following activities be considered as education? If you have a trust which is not carrying on, say, training of actual schools or colleges, not running a school or a college. Say, today we were considering all these as education, say, running a standalone hostel for all students of all communities. Today, for instance, you have in Mumbai, you have a CA hostel for students a well-known hostel for students from outside Mumbai, from a particular community, where they're running a hostel for all students. Not, I mean, there it may be only for CA students. So, but there could be a hostel which is for all students. YWCA runs a hostel for all students, and YWCA does not conduct school or colleges. Now, the way the Supreme Court has read this thing is that if you're a school or college and you have a hostel for your students only, then that is an incidental activity. The question here is that therefore this again, because you're not carrying on formal education at all, then this will possibly not be considered as education at all. Similarly, if you're just conducting examinations and you're not actually imparting, now if those examinations are recognized degree or diploma courses, etc., it's fine. But if they're not, if you're conducting examinations, say for instance, you've got to go do certain your GMAT course or certain things, etc. Now the question, or the test of English, TOEFL courses, test of English or foreign language, etc. Now, or say for instance, for banking, you have for banking personnel, there are certain courses, certain examinations are conducted. For insurance personnel, there are. Now, would this be covered by as education? I think this would possibly not. Similarly, running a nursery and kindergarten, because these are not required to be affiliated anywhere. So would this be education? I think certainly not again. Now, normal, this is that penny trust gives scholarships, prizes, loan scholarships by, now, but they are not engaged in running of a school or college. Now, would that be regarded as education? Possibly not. This will not fall under education, as the Supreme Court says. What you mean by education in the 215 is only formal scholastic education. Unrecognized courses, say maritime training, executive development programs, or courses in music, gemology, computers, etc. Then, various organizations run seminars, workshops, lecture meetings for professionals. Now, possibly that will also now no longer be considered as education. Skill training activities would not be regarded as education. Running vocational courses such as a workshop for the blind, handicapped, etc. That would also not be regarded as vocation now. And then the question arises as also whether certain activities of educational institutions which are running schools and colleges, whether these activities would be regarded as incidental business. The running of a nursery and kindergarten, possibly yes. Running unrecognized courses by such institutions, I think here also the answer may be yes. What about pure letting of premises when not required for the school or college? And we had a couple of decisions in the case of Vilepali Kelwari Mandal and Lala Lajpat Rai Education Society, where this matters had been considered by the High Courts and it was held that it is not business. I think here the question is whether this is, because if it is a pure letting without any other services, possibly it would not be regarded as business. But if you're doing it in an organized manner where you are providing various other facilities along with the premises, etc., it may possibly be regarded as business. But again, I think this is an area where there seems to be a lack of. So as I said, this is something which there will be a lot of litigation on this. There will be a lot of issues which will come up for all education institutions. Of course, today, whether an education institution is at all wise going in under 1023C6, or is it always better to go under 11 and 12 is a question. And because under 11 and 12, at least you have certain benefits which are not available to an institution under 1023C6, such as exemption for capital gains if it is reinvested in the capital asset, or option to spend in the subsequent year, which are not there for 1023C6, but are there for institutions claiming exemption under 11 and 12. So therefore, I think, but these are all issues which will now come up. And as I said, these two decisions of the Supreme Court, frankly speaking, if you look at it, they have set, it's a huge setback for charities. I think, in a sense, the Supreme Court has gone back to the 1970s. What was the concept of education? They said the concept of education pristine, etc. Perhaps the Supreme Court is justified because if you look at the general public perception of educational institutions, the fees that they're charging and the surpluses that they're generating is quite large, very substantial, and they are almost being run on business lines. And that is perhaps where, I think the Supreme Court says it's perhaps time to put a stop to all this nonsense which is happening in the name of education. Perhaps that is the thinking behind the Supreme Court. But when you look at the other, this also, you will realize that that is also a huge, the next decision also, that is also a huge setback for charities, and it will certainly impact fundraising by charities. And that's where I think let's look at that decision. Let's go on to that decision. And that the lead case in that was the case of Ahmedabad Urban Development Authority. And the issue there was on the correct interpretation of the provisor to section 215. As you know, the section 215 is the definition of charitable purpose. And you had a proviso which was inserted from 1989, which said that advancement of any other object of general public utility shall not be a charitable purpose if it involves the carrying on of an activity in the nature of trade, commerce, or business, or in relation to trade, commerce, or business for a cess or fee or consideration, irrespective of how this consideration is utilized. So that was the sum and substance of the proviso to 215, and therefore the issue before the Supreme Court was whether carrying on of a trade, commerce, or business is per se a bar or a disqualification for a charitable trust falling under general public utility, and therefore it will not be entitled to exemption. The Supreme Court here also, then they looked at the various decisions, right, starting from the 1922 Act, and then they came to the 1961 Act, and they looked at Lok Shikshan Trust, and they said that ordinary profit motive is a normal incidence, and if its activity consists of carrying on a business and no restriction, it can be justified that the object involves carrying on activity of profit. But by profit motive, it does not mean that necessarily profit must be earned, nor does it cover a mere desire to make monetary gain out of a transaction or series of transactions. It indicates a motive which pervades the whole series of transactions effected by the person in the course of his activity. So therefore, the whole motive has to be for the purpose of all the transactions you're carrying on is with the objective of making a profit. That is the way they looked at it. And in Indian Chamber of Commerce, the Supreme Court expanded on that. They said that what is the real nature of the activity? Is it ordinary, carried on by ordinary people for gain? Is there something in the constitution against making a profit? Was actually there is a profit or not? But they said the mere fact that services rendered does not mean that it is chargeable to tax, because income is always derived by rendering some service or the other. And then they analyzed the Supreme Court decision case of Surat Art Silk, which again talked about the predominant object. They said that what these words require there, of course, the language at that point of time was that advancement, this main section itself of 215, the subsection itself, it used the words advancement of any other object of general public utility, not involving the carrying on of any activity for profit. Now, the question there was those 10 crucial words, not involving the carrying on of any activity for profit. So those words were deleted in between for a period of 8-10 years and came back in 2009. They came back in 2009. From 2000 to 2009, we did not have those words there. But, what the Supreme Court said is, in this case, is what these words require that the object should not involve carrying on of activity for profit. The emphasis is on the object of general public utility and not on its accomplishment or attainment. So they said that linking of activity with object and not as linking with accomplishment. So it's the object which has so. And then they've analyzed the whole thing. What did the Supreme Court say in that case? That it is not an activity results in profit, but it will be carried on with the object of earning profit, and profit making must be the end to which the activity is directed. And then they evolved, therefore, the predominant object test. But what is the predominant object? Is it making profits or is it carrying on the charitable activity? Then the Supreme Court in this case went on to look at the Supreme Court decision in the case of Tanti Trust. And the Tanti Trust, what the Supreme Court had held is that the business should be incidental, and a business whose income is utilized by the trust for charitable objects is a business which is incidental to the attainment of the objects of the trust. This was what the Supreme Court had held in Tanti Trust. So this was how it reviewed the past law. And then it went on to analyze section 215. That the reason for this change is that the advantage of tax exemption was not intended to charitable trusts that are commercial concerns, which, while ostensibly serving a purpose, public purpose, were fully paid for the benefits provided by them. And in this, they looked at that circular which was issued after once this came in, the circular which was of the CBDT explaining the proviso to 215. And then the Supreme Court analyzed, they said that in Surat's Art Silk, the larger bench agreed that the motivation should not be deriving of profits. However, it brought about the principle of predominant object, and it would, you have to look at, if the predominant object was not for profit and some profits are earned, that would not debar it. But if the predominant object was for profit making was enwrapped or intertwined, it could not be called charitable. That was what Surat Art Silk. And therefore, the dominant object was what was looked at after Surat Silk. Then the Supreme Court went on to say, and look at the binding nature of CBDT circulars. As you know, that this CBDT circular had been issued after the proviso to 215 was inserted, and they said that circulars are binding upon departmental authorities if they advance a proposition within the framework of the statutory provision. So in fact, they looked at the old Supreme Court decisions in the case of Element Lines and Navneet Lal Jhaveri, and then they said that subsequently there is a 5-judge bench in the indirect tax case of Ratan Melting, and that brings out the true position. And that if it is within the framework of the statutory provision, then the circular is binding. If they're contrary to the plain words of your statute, they are not binding. And circulars, of course, cannot bind the court, which have to independently interpret the statute. And at best, they can be regarded as a department understanding on the subject and have limited persuasiveness. So therefore, this is again a very dangerous observation of the Supreme Court and holding of the Supreme Court, because what they did is whatever were the concessions which were given by that CBDT circular, to some extent, they have given that a go by when they interpreted the proviso to 215. And that is where I think, the problem is going to arise, because today, I think all of us have always had this understanding that departmental circulars at least are binding on the department, though they may not be binding on the SSE. And, but now, therefore, this throws a question, does it mean that any officer can choose to ignore departmental circulars? That is the big question which arises. And then they looked at 215, proviso to 215 insertion, and they said parliamentary endeavor is to alter the regime applicable to general public utility category. And the substantial change is the prohibition from engaging in any kind of activity in nature of trade, commerce, or business, or earning income on rendering service in relation and earning income as by cess, fee, or conservation. And they said the express deletion of activity for profit on one hand, and enactment of an expanded list of what cannot be done by general public utility charities if they retain the characteristic as charities is an emphatic manner in which Parliament desired to express itself. And necessary implication is that income received as cess, fee, or consideration derived from prohibited activities is necessarily motivated by profit. Then, of course, they talk about if it is set up by a state department or entity set up by statute, its mandate cannot be treated as a consideration towards state of business. And similarly, statutory boards and authorities whose objective is to develop housing, industrial, other estates, including residential housing at reasonable subsidized cost, which charge higher amounts from some and cross-subsidize the main activity, that cannot be characterized as engaged in business. Or similarly, to provide essential service in larger public interests, such as water cess or sewage cess, such consideration would not be considered trade, commerce, or business. And so, the logic behind this that they've given is that because if it is to be regarded as taxable, such a trade cess, for such an essential service, then the cost of that essential service will go up because that entity is being taxed. Therefore, the cost will go up. And therefore, it is on that logic that they said that this is not trade or commerce or business. On the other hand, non-statutory bodies which mimic this, they're providing the facilities to improve efficiencies or platforms or segment of business. When they claim exemption, their cases would require further scrutiny. So therefore, if you have a water supply board which is set up by the government, it is not a business. But if you have the water supply is privatized and you have a private entity which is supplying the water, then you have to require further scrutiny, is what the Supreme Court is saying. Now, this is, I think, some distinction which is completely, I don't know what the basis could be, but then what Parliament intended was that, any form of activities, trade, commerce, or business, or providing services for facilities, fee, or consideration. And he said that the use of the term in the nature of is by design to clarify beyond doubt that not only business, trade, or commerce, but all activities in the nature of or resembling them are prohibited. Likewise, service in relation to such activities relating or pertaining to such prohibited activities are also forbidden. That is the view that they said. And then they've said that this paradigm shift has taken place, and this is because of the negative language employed by the main part of Section 215. And therefore, this idea of a predominant object among several other objects is discarded. So they said that for the purpose of now, Surat Art Silk was a constitution bench, it was a 5-judge bench, but that was involving the interpretation of a different, the law was quite different at that point of time. There it talked about advancement of any other object of general public utility, not involving the carrying on of any activity for profit. So which was part of the main section itself. It was not part, there was no separate proviso. Now they said that separate, the fact that that was deleted and then this proviso was brought in. Therefore, they said that this whole concept of a predominant object among several objects which was taken there, that will not apply to once the proviso to 215 comes into play. So therefore, that will not apply from assessment year 9-10. Then they went on to discuss about what is a business held under trust and an incidental business. So there's a distinction is what they said, that if you're a business held under trust, what you have to understand is under section 11, what is allowed exemption is only income from property held under trust. Now, if you are carrying on a business, now normally that income from that is not income from property held under trust. But unless that business itself is a property held under trust, and that is what 11.4 says. So if the business has been settled upon the trust, then it is a business held under trust, and therefore where you necessarily have to apply that income to charitable purposes. Just because you are carrying on a particular business and that there's a direction that you spend that money for charitable purposes, that will not amount to a business held under trust, and it may not qualify for the purpose of exemption, is what they've said, and therefore you have 11.4a. Then this incidental business thing, the way the Supreme Court looked at, they looked at the Tantri Trust case. They said, what was Tantri Trust case? That was a case where the main object was education. What was the activity that they were carrying on? They were carrying on the activity of publishing a newspaper. Now, therefore, that activity of publishing a newspaper was in relation to the object, was under the object of education itself. And therefore, that is why the Supreme Court had in that case took a view that it is incidental, because it was under the objects itself, it was a part of the object itself, and therefore it was incidental. That was the way they said. In fact, somewhere there is an observation, they say that it has to be an activity under that object itself, and that profit which arises is incidental. That's the way they've looked at it. And therefore, they said that the Tantri Trust ratio cannot be extended to cases where the trust carries on a business which is not handled the trust and whose income is utilized to feed the charitable objects of the trust. So therefore, if you're carrying on a business which is not coming within your objects at all, and you are earning a surplus from that, though that surplus is being used, if that business is not held under trust, then you're not entitled to the benefit of the exemption, is what the Supreme Court has said. And then they said, of course, the journey was permissible so long as Surat Art Silk and Tantri Trust, so long as the amendments have come. Until that time, it was not. Now the test of charity being driven by the predominant object is no longer good law. And ambiguity with respect to the kind of activity generating profit which would feed the main object and incident profit making also is not good law. That's what they've said. And they said that now, if you are carrying on the incidental business, which the way the Supreme Court has derived, you've got to also meet the test under section 215, the proviso to 215. At one point of time, it was that the income will not exceed 10 lakhs, then 25 lakhs, and then now it is 20% of the total receipts. So that quantitative detail, the quantitative limits which are there under the proviso to 215, that is something which will now need to be met. The plowing back of business income to feed charity is an irrelevant factor. Again, emphasizing the prohibition from engaging in trade, commerce, or business. So then they said that if one understands the definition in the light of the above enunciation, the requirement is that the reference to income being profit and gain of business with a further reference to being incidental cannot and does not mean proceeds of activities incidental to the main object, incidental objects, or income derived from incidental activities. The proper way of reading reference to the term incidental in 11.4a is to interpret it in the light of the subclause 1 of proviso 215. That is, the activity should be conducted actually in the course of achieving the general purpose utility object, and the income, profit, surplus, or gains can then be logically incidental. So therefore, they're saying that that activity has to be in the course of carrying on your objects, then only it is incidental business. That is, and this is the way, then there is no conflict between 11.4a and the proviso to 215. And again, then they went on to say that pure charity does not mean that you don't charge anything. That's the way they said. That if some profit is generated, again, you can get exemption provided that quantitative limit under proviso to 215 of 20% is met. And then they said that another way of looking at the definition of charitable purpose along with 1023C and 11. Now, incidentally, this talks about 1023C, and again, for achieving a general public utility object, if the charity involves itself in activities that entail charging amounts only at cost or marginal markup over cost and also derive some profit, that prohibition against carrying on business or service related to business is not attracted if quantum of profit do not exceed 20%. So what they're saying is that if you're charging amounts at cost or marginal markup over cost, then that is not business. But if you're deriving substantial amount over cost, then that was a profit, which will, there you have to apply the 20% limit. And then they give some illustration Gandhi Peace Foundation disseminating Mahatma Gandhi's philosophy through museums and exhibitions, publishes works for nominal costs. That is not business. Providing access to low-cost hostels to weaker segments of society, where the fee or charges recovers the cost plus a nominal markup. Renting of marriage halls for low amounts, again with a fee bent to cover costs. And blood bank services, again with a fee to cover costs. But when the entity concerned charges substantial amounts over and above the cost it incurs for doing the same work or work which is part of its objects, such as publishing an expensive coffee table book on Gandhiji, or in the case of marriage hall, charging significant amount from those who can afford to pay by providing extra services far above the cost plus nominal markup. Such activities are in the nature of trade, commerce, or business or service in relation to them. In such cases, you have to then apply the proviso to 215 and see whether they fall within that limit of 20%. And then they went on to analyze the different types. So this was what they said. So therefore, they said this concept of nominal markup over cost or substantial markup over cost. If it is nominal markup over cost, it's not trade, commerce, or business or service in relation to trade, commerce, or business. If it is substantial markup over cost, then it is trade, commerce, or business or service in relation to trade, commerce, or business, and which is hit by the provision. That is the way the Supreme Court has analyzed the proviso to 250. Then they went on to look at various types of authorities or bodies which were there before them. And statutory authorities, they said that those who carry on statutory income, again, they are involved in advancement of general public utility. They may also be involved in certain activities which are for promoting, etc. That is, but they've laid down certain criteria which how do you judge that, and which I will not get into too much detail. If one reads the decision, the conclusions on each of these, you can immediately get the whole. They said that, therefore, is it furthering the GPU object carries out, if it carries out an activity which entails some trade, commerce, or business, but generates profits, and quantum is within prescribed limit, it is then is a general public utility. But primarily, they said that if it is carrying out a statutory function, it is primarily not business. That's what they've said. And even if it is cross-subsidiary, that is also not business. That is the way they've looked at it. Then they went on to look at certain statutory regulatory authorities. And the statutory regulatory authorities, particularly they looked at the Institute of Chartered Accountants of India, which was one of the parties before them. And they said that normally it is, per se, it is not business what they're carrying on. Bodies will regulate professions that are created under statutes which are enjoined to prescribe compulsory courses and continuously monitor content of its members, do not primarily carry on activities in nature of trade, commerce, business, services, relations. But, and this is where the problem lies, they said that while considering the nature of activities that these bodies perform, whether the kind of consideration charge is vastly or significantly higher than the cost it incurs has to be looked at. For instance, there can be regulatory fees which have to be paid annually, or the body may require candidates or professionals to purchase and fill forms for entry into the profession or for examinations. And if the level of such fees or collection are significantly higher than costs, such income would attract the mischief of proviso to 215, and therefore it has to be within the monetary limits prescribed under the proviso to 215. Seeds Act, they said that is for the benefit of the public and etc. and all that. So therefore, this is a public service which is being performed, and therefore it will not amount to a trade of commerce or business. Then they looked at the trade organizations and so trade promotion bodies, councils, and associations, organizations. And particularly the lead case which they looked at was the Apparel Export Promotion Council. And they looked at what are the figures of the income and expenses and all that. And they looked at the whole thing and they said, when a trade promotion body provides individualized specialized services such as conducting paid workshops, training courses, skill development courses, and hires venues which are let out to industrial training or business organization to promote and advertise their respective businesses, their claim for general public utility status needs to be scrutinized more closely. Such activities are services in relation to trade, commerce, or business. And these activities in the facility of consultation or skill development courses are meant to improve business activities and make them more efficient. And such receipts are clearly fee or other consideration of providing service in relation to trade, commerce. And there they said that it cannot be said that Apparel Export Promotion Council does not involve any element of it. Cannot be said that it does not involve trade, commerce, or business or service. Though the benefit recipient may be individual business or exporter, there is no doubt that they continue. The objective continues to be trade promotion, and they are actually carrying on the general public utility policy activity. Therefore, for them, you have to test whether you meet the 20% test or not. Is what you have to mention. Look at that. Look at the under the proviso to 250. Then they looked at a couple of institutions which are set up. 3 institutions which are set up by the government. One was EarnNet, which provides internet services to certain government departments, etc., and domain registration for certain ac.in, edu.in, and rest.in. And they said that materials on record do not suggest they were carrying out basically an essential service. Materials don't suggest that the receipts are such a nature to be called as fees or consideration for business, trade, or commerce or service. And it is vital to development of online educational and research platforms, and therefore it is entitled to benefit of exemption. The National Internet Exchange of India, which regulates the domain .in, which grants that this, and it says it carry on essential, crucial purpose of promoting internet services and regulating domain name registration, which is extremely essential for internet users in India. And therefore, the revenues contention that it does not merely carry on public purpose or regulate, but is involved in trade commerce, cannot be accepted, they said, because this is a crucial thing. But the third one, which was GS1, there they looked at again the figures, and they saw that the amounts of surplus was quite substantial every year. And they said that no doubt it is of general public utility, but the services it provides is in relation to business, trade, or commerce primarily. Though it may be eligible to provide in other sectors, it may be true that is capable of being used by other sectors in the welfare of public interest fields. But we don't know what is there. There doesn't seem to be anything. Materials of record show that it's used for commercial or business purposes, and therefore they are not entitled to. So therefore, if you look at it, all three were set up by the government. All three were for essential purposes, but that was not. Then they came to State Cricket Association and they said that, there is no doubt it will not fall within education. It is certainly not education. That's what they said. Then they said that apart from amounts received from sale of entry tickets, they also receive advertisement money, sponsorship fee from the BCCI. And BCCI sells media rights on behalf of the state associations. Then they looked at the fact that only a fraction of income has been expended towards promotion of cricket, that is for the training, etc. Very small amount has been spent. And it's quite evident that these are run on business lines. And at a close receipt of the expenses, the expenditure does not disclose that any significant proportion is towards organizing coaching camps or academy. And therefore, they've said that colossal revenues have accrued to the BCCI from sale of media rights. I think this is something which has colored it. And this is, the BCCI auctions these rights on behalf of state association. Therefore, these rights are apportioned commercial, and therefore the high courts fell into area that, the error by saying that these are in the nature of infrastructure subsidiary received from BCCI. Really, BCCI is sharing those revenues from sale of those media rights with the state association, cricket association. Therefore, in this case, they said that, okay, this should be examined, the relative relevant documents, resolutions, individual agreements of BCCI with these entities need to be examined. And therefore, to that extent, we are restoring it for examination in state cricket associations. So the conclusions which they've given here again is, and one of they've summarized the conclusions. And let me tell you, this is one of the few decisions. It's a 149-page decision. And on the first page, you will find actually an index to the decision. So it's a good thing because such a long decision, otherwise how does one understand? But, a whole index is there to this decision. And here in the conclusions that they've given, that generally charging of any amount of consideration for advancement of general public utility, which is a cost or normally cannot be considered to be trade, commerce, or business, or any service in relation thereto. It is only when charges are markedly or significantly above cost that they would fall within the mischief or cess or fee consideration towards trade, commerce, or business. And they said we've given the illustrations for that. And 11.4a must be how much interpreted with 215, as we said, what is incidental business. Then about the statutory bodies, etc. Since they are essential, they have to be excluded from the mischief of business or commercial receipts. And they have to apply the mind and scrutinize whether the charging substantially above cost, etc. Again, they've seen statutory bodies. Again, as I said, we've examined that so far as the institute concerned. AEPC, if organized, provide additional services, as I said, that is something they would be business or commercial in nature, is what they've said. GS1 India, I said. Then there were certain other trusts, and particularly the Tribune Trust, where we said that in this the Tribune Trust is, though the objective is that of education, it is publishing a newspaper, and publishing the newspaper, it is inviting advertisement, and therefore this advertisement expenditure, it is certainly business or commercial receipts, and therefore if it is within the limit of 20%, it's only then that they would be entitled to the benefit of the exemption. That was the view that the Supreme Court looked at over there. And so what the Supreme Court here says is that this scrutiny has to be done, whether they exceed this quantitative limit has to be done on a yearly basis, and whether the activities amount to trade, commerce, or business based on its receipts or income has to be looked at on a yearly basis. If they're found to be the nature of trade, commerce, or business, then you look at whether that limit has been breached. So every year, when you look at whether it is at cost, marginally above cost, or substantially above cost. If it is substantially above cost, then it may amount of business. If it is amount of business, then you see whether the 20% limit is being met or not. And in fact, this Supreme Court decision at times has, there is, to some extent, it is written in such language where sometimes there is conflicting views. It seems to be conflicting at times. So in fact, the revenue sought a clarification as to what exactly is the implication of that on various SSCs which were there. And the Supreme Court said by its order dated 3rd November 22, a clarificatory order, again, Ahmedabad Urban Development Authority was the miscellaneous application, was decided. He said that the application of law declared applies for the assessment years in question which were before this court and were decided for those relevant assessments. Whenever the appeals have been decided against the revenue, they have to be treated as final. For assessment years which the court was not called upon to decide, concerned authorities will apply the law declared in this judgment, having regard to the facts of each such assessment year. So, therefore, say for the institute was before the Supreme Court for, say, 2 years. Then those 2 years, it's governed that they're entitled to the benefit of exemption. But for the other years, are they entitled to the benefit of exemption? Is a question mark. It will have to be examined by the officer. So, for those 2 years, if you look at the facts, which was the Supreme Court, the income was not so substantial. But in subsequent years, where the income has been substantial, what happens, I think, is an open question now, which will be again be subject to a matter of litigation. Now, the issues which arise from this decision is that does every high surplus activity amount to trade, commerce, or business? Of course, there could be activities such as interest or rent, etc., which may, or capital gains, now which may not amount to trade, commerce, or business. Possibly one can argue that by the fundamental nature is not an activity which I'm carrying on. It's merely a passive income which I'm earning, and therefore passive income perhaps may not be. But if you have any activity which you're actively carrying on, and where you're earning a substantial surplus, there's substantial markup over cost as analyzed by the Supreme Court, then that would definitely amount to trade, commerce, or business. Now, what percentage is significantly higher than cost? Now, I don't know. There's no answer to that. Would 5% be substantially be marginally above cost? Possibly yes. Would 10% be marginally above cost? Possibly yes. What about 20%? Is it substantially above? One doesn't know. What about 15%? Is it neither here nor there? What is so? Therefore, it's now again. Surplus arises due to your budget. You budgeted certain, say for instance, you have a certain program you organize, and you budgeted that yes, you'll have 200 people. Actually, there's an enrollment of 300 people, and therefore, because your fixed costs are divided upon a larger number, you have a substantial surplus. So, is that something which is impacted? It seems the way they've said that you look at the figures is what the way we've said. And then what expenses form part of cost? As you know now today, capital expenditure on objects is an application of income. Now, do you look at capital expenditure for the purpose of determining cost, or do you look at depreciation? If you look at the institutes or how they've analyzed it, they've looked at depreciation in the Supreme Court. Now, is that the way you look at it, or is capital expenditure? Because depreciation now, as you know, is not allowable if you claim the capital expenditure. But so therefore, how should one look at it? Because various entities, what they do is the surplus is redeployed in the capital assets for in expansion, etc. Would write-offs form part of cost? What about notional cost of voluntary service? In India today, it is only donations in kind, which is in tangible form, where you are supposed to recognize it, maybe at 1 rupee. The Institute Technical Guide says you can recognize it at 1 rupee. Or you can obviously recognize it at its fair market value if you... But today, a large number of organizations work on voluntary service of the volunteers, including this organization. I think there's a large amount of voluntary service. If you factor in the cost of those volunteers, then there certainly is a loss. Internationally, charitable organizations do account for voluntary free services received from volunteers. That is also accounted for, recognized. Now here, because the one is not factoring in that, therefore, does it appear to be a surplus? Can one take the argument that yes, this voluntary service, if one factors in that, therefore there is really no surplus in that sense, is a question mark again, because say today, for instance, for a program, you may have faculty who speak and do not get any consideration at all. So therefore, if one were to factor in their consideration, possibly the amount would have been significantly higher, the cost would have been significantly higher. And then, as I said, if high surplus is due to large volumes, the fee is nominal. Say, for instance, you're conducting an exam for which you're charging 100 rupee fee, but because it's an online exam, your cost is very small because there are a large number of people who take the exam. Therefore, you've got a huge surplus. Is a question mark. What is that covered? Now, what if their surplus arises due to grants or due to interest income? Now, if it is interest income, I think certainly that is not an income from the activity, and therefore that would not have to be considered for the purpose of that. But if your surplus is arising due to grants, now it depends on what is the nature of that grant, whether it's a one-time grant which you receive, which was not anticipated, or is it a grant which was anticipated and which you're receiving every year? Say, for instance, many organizations receive salary grants. Now, when you're receiving a salary grant, when you're pricing your services, does it mean that you should price your services by not factoring in the cost of the employees, because your cost of employees is reimbursed through a salary grant? I think is a question mark. So therefore, if a school is charging fees, normally if it's an aided school, then the fees are reimbursed. Of course, most aided schools will fall under 3AB of the Income Tax Act, 1023C 3AB, and therefore this question may not arise. But just to illustrate, this question will arise, that if it is in relation to grants, what will happen? Now, if your objects are medical, educational, relief of poverty, and not general public utility, does this decision apply? Technically, this decision does not apply. The concern is how would the department look at it? What is going to happen so far as the other charitable entities this is concerned? Because actually, if you look at it, the provisor to 215 applies only to, and the Supreme Court was concerned only with the provisor to 215 in this decision. But when you read this along with the educational institutions decision, I think one is seeing a trend of the court towards saying that charitable entities should fund themselves only out of donations. They should not make a surplus. Now, I don't know whether that is realistic. In fact, in Surat Art Silk Mills Association, they said it is unrealistic to expect an association to have only cost, charge only cost, or have a marginal surplus or negligible surplus, because you cannot anticipate what your income revenues are going to be, and that is where it's impracticable, is what they said. And that whole this thing has been given a go by the Supreme Court in this decision, unfortunately. If your incidental business, if your charitable activity itself is regarded as a business and you're not carrying on any other activities, then how does one maintain separate accounts? Would you say for the investment income you maintain separate accounts, for the rental income? So investment and rental income you maintain separate accounts, donations also part of that, and activity you keep as a separate. And the biggest problem is, what about fundraising activities which are carried out by various trusts? You may have a fundraising event such as a music concert, a film show, or auction of painting, etc. Is this a business now? Would this amount to trade, commerce, or business? If, are you making a substantial surplus from that? This is a question which will arise. There are also organizations which, say for instance, where the beneficiaries themselves make certain objects which are then sold. What happens to such cases? There will be a substantial surplus. What will that amount of business? Or this question of which came up before the Bombay High Court in the case of Nashik Panchavati Pandrapol, where the activity was of maintaining aged cows. Incidentally, milk was the product of maintaining these aged cows, and that milk, instead of allowing it to go waste, it was sold at market prices which would enable the funding of this activity. Now, there the Bombay High Court had said that no, you look at the predominant purpose test, and therefore the predominant purpose is charitable, and therefore would not. But now, what would this happen? Now, therefore, so does it mean that charities are now expected only to fund themselves out of donations and interest, etc., and not earn any surplus on their activities? I think this is it will have a very significant impact on most charities, I would say, because most charities do have some form or the other of fundraising activities, which are used as to raise funds and which feed the main objects. Those activities are really not actuated. So that is the whole problem which will arise, which was. So this, I think, covers the issues which I wanted to cover, and we can now take up the questions. Whether the Apex Court decision is applicable to 1023C only or Section 12AB registered trust. The language is separate from Section 11. I think technically, yes, it applies only to 1023C. The concern is when you take both the decisions together, whether this will be extended to other activities is the worry which is there, though today it does not apply to other activities.
Chirag, if you can read the question, please.
Can an educational institution registered on 1023C switch over to register on 12AA now, 12AB? Now it is 12AB. See, you have to select, you look at Section 11.7. Section 11.7 says that you have to make, if you have opted for 1023C, once you can switch over to 12AB, and once you have made that decision, you cannot then go back to 1023C. Yes, it should be possible otherwise, if you are registered under 1023C. Does the decision apply to medical college having teaching hospital as well? If yes, how do you apply the decision in that case? Yeah, so now the question is, in a medical college, that is certainly, I think, education, because I assume that those medical degrees is affiliated to some university, etc. So therefore, it will certainly be education. Then, of course, the question is, what about the hospital? Would the hospital then fall under clause 6A? I think that's the way you probably may have to look at it. 6 and 6A, both the clauses together. That's how you would have to look at it. But so far as your teaching activity is concerned, are you having a huge surplus from your teaching activity is what you will have to show. Possibly, if you're medical college, of your hospital, you're having a deficit, and that deficit is on account of your teaching activities being made good to make good the deficit. One will have to show that this is really an integrated activity you are doing, the college plus the hospital together, possibly. But yes, there could be certain challenges faced in this situation. This donation to an editor would be application. So I think, yeah. So donations per se would not amount to education now. Is the way the Supreme Court has looked at education under the proviso 215, donations would not amount to education. Educational trust having its place will be due for running of school, revenue will the entity of the trust will provide school. I think it's a fact-based rather than let's, because on each entity there will be issues which will arise. And as I said, see what is happening is, unfortunately, and which I think perhaps this question is, that many trusts, because education has to be provided only by a charitable organization, so many trusts, societies, etc. are there. What is happening is that today they are being commercialized by having an entity which is rendering services to that, and that entity is taking the fees and giving or a large percentage of the fees and incurring part of the expenses, whereas the school only has certain amount retained by it, and that is where the concern possibly is that this commercialization of education is what has prompted the Supreme Court in this case. Mentioned about state law, whether not following something mentioned in new education would lead to denial. Possibly it could be the thing, because today in any case, it talks about for 1023C purposes, non-compliance with any law material to the attainment of its objects is one of the things. So possibly this would also, this new education policy, if you don't follow the quota system, etc., that is something which may be a hit. Okay, then the next decision, which is the Ahmedabad Urban Development applicability to clubs and gymkhanas. I think this is going to be a problem to them. The question is because, this activity is definitely general public utility. It's clearly not education, not falling under any other limbs, is the way I would look at it. Now, if they're having substantial markup over cost, definitely I think they will be hit and they will have to, and which is what happens, that principle of markup. Now, the question of principle of mutuality, yes, now the question really is this, and which again, can they claim exemption under mutuality? Yes, the CBDT circular at that point of time also had said you can claim mutuality. The question is, are you rendering services only to members? See, mutuality and charity are actually two different things. In mutuality, what I'm saying, you're saying I'm rendering services to members. In charity, what I'm saying, I'm rendering services to the general public. Now, what are you for? Are you for the members or are you for the general public? That's something which you have to decide and accordingly claim the exemption. Mutuality, yes, you may be able to claim the exemption for the member subscription and this thing, but you may not get the benefit of the exemption for the interest income, etc. That's the. Then in para 2, court has not made any distinction between fees charged for marginal profit and beyond marginal profit. Okay, where fees are charged for seminar, it will always amount to business. No, I think there also this marginal profits principle would apply if you're rendering services, because even in relation to business, if you're rendering services, there also this concept of marginal markup and substantial markup you have to look at. I think that's the way. Other questions, if trust is engaged in activities of objects relief to poor, will that be impacted? Again, if it is only relief to poverty, possibly it may not be impacted today, but yes, going forward, this question may come up. So today, that's the thing. And trust, and fortunately, I think if you look at that CBDT circular of of 2011, they've said that what is relief to poor. They've talked about widows, orphans, etc. All that is also be regarded as relief to poor, said, and aged also. That is also. The question is, whether that circular is now binding. Again, that's the open question which has been thrown open by the Supreme Court. And unfortunately, the Supreme Court has laid open so much this thing that it's created more of a controversy rather than just settling the controversy. Some controversies have been settled, but many other controversies have been opened up by this decision. Trust registered at any rental income, not into, yes, I think certainly one can say if it is pure rental. But if you're rendering an activity of, say, a daily rental along with which you're providing decoration services, you're providing catering services, etc., then there could possibly be a problem. Amendment of objects may take more than 1 or 2 years. What is the fate and exemption? I think once you show that you demonstrate what Supreme Court has said, that yes, we are giving you time to do this thing, and therefore, if you started the process and you filed your application before the end of the year, I think that should be good enough for, and ultimately, that has been allowed by the court. I think that should be sufficient to give you the benefit of the solely, of the term solely. Yeah, how to determine? Your guess is as good as mine. Frankly speaking, I think we don't know whether 20%, 10%, 5%, 1%, 2%. One doesn't know what is this marginal. Whether test of trade, commerce, or business needs to be applied for each transaction. I think here you have to look at that activity as a whole. Are you running it on that activity as a whole? Is the way you have to look at it. What is distinction between business under trust was carried on? I think you should read the judgment that they say that there was a doubt as to whether 11.4 and 11.4a have to be read together or they are operate in separate spheres. The Supreme Court seems to indicate that they operate in separate spheres. That's the way they've read it. Then whether membership fees earned by charitable institutions cannot be allocated to undertake any individual activities undertakes, but many events undertaken annually. Does that need to be tested for trade commerce? I think membership fees possibly by itself may not amount to, because we are rendering various services to members, etc. Possibly that may not amount to, but again, it depends on the quantum of membership fees. Are you charging far more than the services which are rendering to members? I think it's again a question mark, because is this business activity that you started off creating a membership and charging substantially? If year-on-year surplus is generated and offered to tax, whether during re-registration, tax authorities can deny charitable status, alleging that no charitable activities are undertaken. See what the Supreme Court is saying. It's not, they're saying that you will not go out of the general public utility. If you're carrying on charitable activities, just if you're rendering surplus, then you test it on the touchstone that 20% is what they've said in this case. And this is again only for general public utility trusts. So that's the way they've read it. And as I said, that today this decision applies only to general public utility trusts. It does not apply to any activities in falling under other limbs of charitable purpose. But tomorrow, one does not know whether this will then be extended, etc. So how this will be looked at, whether the department will try and extend this to other, and that's the real concern. And which is where then it will create havoc among charitable organizations. I think they will be starved of funds for charitable activities, and therefore I think some sort of clarification or by the CBDT is essential, or because this is something which will create a huge problem for the entire NGO sector. An educational trust availing exemption under Section 1023 3AB having its own place is entering into an agreement with another entity where school will run, and this I think was there, whether that will by that entity the revenue earned will be this thing. So whether this will be a profit making, etc. I think the facts is what you'll have to look at. Possibly the department may certainly challenge such, as I said, because this is what they want to challenge, that the commercialization of education is what is, I think, is what is intended to be tackled by this, the way the Supreme Court wants to. Sorry, there's one more question. Does the new Nobel Education judgment give the department opportunity to raise questions on the operation of entity already registered under 12AB? See, today what happens is, now let me put it this way. There are two aspects to it which I will, now what is the impact today? Today, if the proviso to 215 applies to you, one is that Section 1310 will apply to you. You will not lose exemption for your entire income. What will be taxable is your gross income less expenses which you have incurred on your objects, other than donations made, other than capital expenditure on objects. So that is one part of it. The second is that when you apply for registration under 12AB, you have to indicate under which category you fell. Now, if you have indicated education and you're not actually carrying on schooling or college running of colleges, then possibly now you may not fall under education and you may now fall under general public utility. And therefore, when your case comes up for renewal, at that point of time, you will have to fill out the form and change that or ensure that you fill it up correctly based on the Supreme Court decision. Looking at that, that's the other thing. But entities which are already registered under 12AB, in any case, the department can look at it on these operations. Is it general? Is it a business activity or not? And that has been, the litigation has been going on for the last 10, 12 years. We've been seeing this litigation going on, where any number of cases have been coming before the courts. And I see that that will only increase with this, with the Supreme Court decision. The number of cases before the courts, etc., will further increase. I think unless the government comes out with some clarifications to ensure that genuine charitable trusts are not hit, as was the intention of the proviso 215. Unfortunately, see the way it has gone, and it's ironical. The proviso to 215 was brought in to overcome the ratio of the Supreme Court decision in the case of Gujarat Maritime Board. Now, in this case, the decision in the case of Gujarat Maritime Board has been upheld effectively by the Supreme Court. They've said that this is a statutory entity rendering services for the purpose of, and therefore it will get the benefit of exemption. All the statutory bodies have got the benefit of the exemption. I'm told Mr. Suparkar yesterday was there, and he was one of the counsel before the Supreme Court in the matter. And he said that MMRDA was one of the parties over there, and MMRDA, as you know, has huge funds, huge surplus. So therefore, the amounts involved are huge. But those bodies have got the benefit of the exemption. It is the benefit has not gone really for other entities which will get hit, particularly private entities, which are public charitable trusts, which are not affiliated to the government, etc. Those are the ones which will get hit the most. Whether activities of religious nature can be classified as general public. No, religious does not fall under the definition of charitable purpose at all. So fortunately, right now, religious will not get hit. So even if a religious entity carries on a business, that will not hit by the proviso to 215, it will not get impacted at all. It will get the benefit of the exemption. Then in case of a club, they have an AOP which just caters to members and does lots of projects, and this is charitable trust which collect and projects are executed by the AOP. Can they claim exemption? I think it would depend on the facts, but yes, the club can possibly claim mutuality. So many Rotary clubs, I understand that they have clubs which is separate and charitable trust which is separate. So for the Rotary club itself, they can claim the benefit of exemption on the ground, or the Lions club, they can claim the benefit of exemption on the ground of mutuality. So far as the trust is concerned, there you'll have to look at the income of the trust. How does it raise funds? If it's pure donation and interest income, there is no problem at all. If it's carrying on certain activity which is giving it a surplus, then you have to look at whether it is general public utility, whether it can be hit by the decision. That's the thing. Then decision under section 11, which says that medical object is itself charitable and surplus doesn't matter. Is such ratio valid now? For the time being, yes. But going forward, whether this same thing will apply to the other limbs of section 215 is a question mark. And that is the real concern which one has. That right now this ratio of this decision applies squarely only to any other objects of general public utility. So then. Sorry. The next question is, would membership fees collected by membership-based organization be hit to justify nominal substantial markup? I think perhaps, yes, if there's substantial surpluses, perhaps it may get hit. Pharmacy run by hospital run by trust on cost plus basis. Yes, if it is charging a nominal, maybe 5% markup, then possibly one can say that. Whereas commercial entities charge 25-30% markup, I'm charging only 5%. This is nominal markup. It's not run on commercial lines, and therefore possibly that would. And again, of course, it depends on whether the hospital will probably fall under medical, and it may, to that extent, this decision does not apply. And does the new Nobel Education judgment give the department of that we've already covered that when registered or 12EB. Then whether letting out of 50% of building held for charitable activities to private as well as government bodies tantamount to carrying on trade business or providing service to trade commerce or industry, whether charging or market rate will be differently treated. See, if it is given out on a pure leave and license, now that is, see, today I have various assets. I have assets in the form of funds which I deploy in fixed deposits. I have assets in the form of immovable property, which I'm earning rent from. So just as I'm deriving interest from investments, I could be deriving rent from if it's a pure rental arrangement or a leave and license arrangement, then possibly this may not fall in business at all. And one could say that the question is that it may not amount to providing service to trade, commerce or industry and what the Supreme Court had in mind, where it's a pure rental arrangement. But as I said, it's a slightly gray area as to whether this will be covered. But if you're doing it on a short-term basis, so definitely if you're doing it on a daily basis, etc., then it definitely is hit by the decision. Education trust and sports ground, they collect charge for morning walk. What is the status of income? This will be fee consideration for fee. Now, what is the cost of maintenance of the ground versus what is the fee that you're charging? You will look at it. Is it substantial surplus? And this will be general public utility. So this may get hit by this. You have to look at it. Overdue decision solely in Queen can be taken care of prospectively, but not for the purpose of business. It's going to be subjective and give rise to fresh litigation. Would it have been better to avail 11 and 12 as higher profit would be plowed back for charitable? Now, there also under 11 and 12, if you're general public utility, of course, education, possibly yes, there you can get the benefit. But if you don't fall under general public utility, but incidental business, they will look at is this incidental business? Are you earning surplus from incidental business? That could definitely get hit. The activity of education itself, till today, it may not get hit. But understand one thing, that today, I think the concern is, if you have today a school which is charging absolutely very high rates, they're having a huge surplus. This is what is being looking at the government feels and the public also feel that, is this not really taking advantage and this is not really education? Why should they get the benefit of tax? And that's what the Supreme Court is saying, that you are recovering your charges. Why should you get the benefit of exemption? You are recovering and you're making a huge surplus constantly. Similarly, hospital. Today you have corporate hospital and you have trust hospitals. What is the charges that they are being charged? That is the concern, I think, which is there, which is what the Supreme Court has probably prompted this decision. And that is where I think, one will have to see as to how, the law develops. But I think the law has, what was happening is that the law was going in one direction all along. And suddenly one finds that the law has been completely changed in the opposite direction. And not only in the opposite direction, you have gone back 40 years, 50 years. And therefore, it's something, and in fact, I would say not even 40, 50 years, you've gone back much more. And therefore, today, I think the trusts will be severely handicapped, particularly those who carry on general public utility. I think this is going to be a serious problem for many trusts. Alumni Association of College, can they pursue general public utility object? Alumni Association, what is the object? I don't know of the Alumni Association. Is it to just meet and exchange views or contribute to the college? Now, that may not follow charitable activity at all. It may be a members association which follows under mutuality. I think it's something which one will have to look at each case, how it is structured.